Hello, my name is Jeff Guyman. I am the owner of Guyman Law, LLC. It's a criminal defense law firm in Cincinnati, Ohio. I just wanted to touch base and notify everyone of an issue that I've seen come up recently, and it is in regards to um, marijuana in the state of Ohio and how it is impacted by the legalization of marijuana last November in 2023 here in Ohio. Uh, that's when recreational marijuana became legal for the first time, uh, following medical marijuana by nearly a decade in 2016 when medical marijuana became legal in Ohio. We are the 24th state to legalize recreational marijuana. The issue is, although recreational marijuana is legal now in the state, the rest of the laws haven't caught up to it. And so I want to talk about OVIs today, and particularly marijuana OVIs. There are four different ways you can be charged regarding a marijuana OVI. The first of which is by having, being impaired by marijuana. The state would have to prove that you were in fact impaired while you were operating the vehicle, and under the influence of marijuana. The second way is by having an illegal level of marijuana in your system, which is generally not used because are charged because marijuana is metabolized by your body and turns to metabolites, and so that's not often charged. The third way is by having an over threshold amount of metabolite in your bloodstream or urine. Those are the two ways they test it, and that is often charged that way. It's per se charge, meaning that all they need to show is your levels were above whatever that a level is in any given state. That's deemed to be acceptable. This isn't just applied to Ohio. Again, the same thing. If it's a per se charge and if it is based on the levels in the blood or urine of the metabolite, the same issue is going to arise. And so I'm going to get into detail out here in a second. The last way they can prove this charge it is a combination of impairment, showing impairment, and the metabolites in your system of marijuana metabolites in your system. Combination of two. In that, if it's charged that way, there's a lower showing necessary for the total metabolites in your system because they're also having to prove impairment. The main ones we're going to focus on here are the last two. Okay, so those are the metabolites, where they're having to show a certain level of metabolites in your system, and why it's so problematic. This applies to not only recreational marijuana, but medical marijuana as well. So often clients are getting charged with OVIs, marijuana-based OVIs, based on there being too much essentially metabolites under the law in their system. And how long those metabolites remain in your system differs depending on how they do the test. Whether it's through blood or urine is going to change how long it's in your system, and how much is deemed to be acceptable. The issue is when they're doing this test, when the test is getting sent off to the Bureau of Criminal Investigation, BCI, which is often used here for a lot of agencies and smaller departments, or whether it's an in-house police department doing the test, sheriff's department, whatever it may be, they cannot distinguish between active and inactive metabolites. So inactive metabolites are metabolites that are in your system from ingesting marijuana, but that have no impact. They're not active. They have no impact on your ability to function. They cannot cause impairment, but yet they are considered when looking at the total amount of metabolite in your system. There is no differentiation. So you can get pulled over and have a over the level threshold of metabolites in your system of marijuana metabolites and still get charged with an OVI even though you're completely fine to drive. Okay. The reason this is obviously such an issue is some of these can stay in your system for weeks, again, depending on what test is done. Weeks. And if you are either recreationally using, some recreational users use every single day, or at least multiple times a week. Some smoke heavy. So if you're recreationally using marijuana and are pulled over at some point in time, and the officer deems that he thinks perhaps you're impaired, and it gets to a point where you submit to a test or your blood is taken potentially with a warrant, and you have over the level threshold of these metabolites in your system, you may be facing an OVI charge. So this is why it's such a big issue. And again, this is a per se charge. All they got to show is you have those in your system. So what do you do about it? Well, it's complicated because, again, this can apply to medical marijuana as well. If you were prescribed it, unfortunately, the state doesn't view medical marijuana while it's legal. They don't view a medical marijuana card, the same as a prescription. So if you're given a medical marijuana card and you use and you drive, you're still at risk of these same things happening. And some people, again, use medical marijuana every day. There are a lot of things. Obviously, the first thing is if you get pulled over, this isn't legal advice. I'm not your attorney, but generally speak with your attorney, whoever is representing you. Very rarely would I suggest somebody submit to a test voluntarily because you open yourself up to all of these potential complications. Now, there is a 1-year suspension of your license that will happen for refusing to submit to a test. However, that 1-year suspension in comparison to, being at risk of an OVI is the consequences that can come with an OVI conviction, it's a lot more serious. Again, though, this is not me giving you legal advice. It's just something I'm saying I would talk to your attorney about. As far as attorneys out there dealing with this, I would love to hear your, how you've went about it. One thing that I think I've seen as being successful certainly is jury trials. If it gets to it where you need to have a trial and you're trying it to a jury, explaining the inactive metabolites, explaining their inability to impair the operator of the vehicle, having experts testify if necessary to how they are inactive and how nearly it's impossible to distinguish between the two, as well as to prove impairment based on those metabolites. Those are all very helpful. Potentially also having individuals, speak to the reality that very often medical providers of medical marijuana do not talk about these, risks with their patients. So they don't let them know how long it can stay in their system. They don't let them know that they can't operate a vehicle, essentially, if they're using these things, because they could potentially be, over the limit. They don't talk about these things. And so a lot of times the person who is using it doesn't know themselves. And so these are all really very real concerns. There's certainly things you can do, strategies that can be taken, and measures that can be used to fight these charges and to avoid them happening in the first place. Again, number one thing is do not talk to the police officers. Very rarely, you can talk to them, but not about the case, anything going on. My suggestion generally is do not submit to any tests. Again, you will need to talk to your attorney, but you're opening yourself up at that point where they're trying to pull you out for field sobriety tests or asking you to take any sort of test. They've already made up their mind that they think you're intoxicated. So this isn't something where, you're going to do them, they're going to let you go. That's very rarely the case. So keep that in mind. Again, just make sure you have a good attorney, a good DUI attorney, someone who has experience with that, to reach out to answer these questions. But I've seen it time and time again, where people are not being notified about how long they can stay in their system, and that they can, in fact, be charged with something just because their levels are high enough, potentially be facing an OVI, even though there's no actual impairment. And so this is something I do believe the law needs to, catch up on. I believe similar to, the issue is a lot of times too with like OVIs, alcohol, OVIs, it's not the same. Like, so in alcohol, you have 0.08 is the legal limit. And we can pretty well say that that's an okay cutoff point. If somebody's over that, they probably are at least slightly impaired. Maybe they shouldn't be operating a vehicle. but alcohol does not stay in your system for weeks. So it's just, it should not be the same thing. I believe, in my opinion, of course, that the legislature should make changes to where impairment does have to be shown if it is a marijuana-based OVI. However, that's for a whole nother day and a whole nother conversation. But anyway, the point of this was be aware that this can happen. And this is certainly a possibility. So again, I would, if you find yourself in a position where you're pulled over, you're either prescribed marijuana or you're smoking recreationally in Ohio, even though it's legal, make sure you protect yourself, make sure you speak to an attorney, and just keep this in mind, that inactive metabolites can still be picked up on tests and are factored in when looking at the per se limit of what is allowed in your system. Hopefully this was helpful. Again, my name is Jeff Guyman with Guyman Law in Cincinnati, Ohio. If you have any questions for me, please post them in the comment section. I will post also my email address below. Feel free to reach out about anything, and I hope you all have a good day. I will be doing regular videos. I want to continue this series because there's other things I have to talk about. I just don't want this video to be too long in regard to the state passing recreational marijuana and issues we're seeing. There's a lot of issues, and fortunately not a whole lot of solutions yet, but I believe we're getting there relatively soon with the right people advocating for it.